Jocko Willink, please cut the Gordian knot. What's that knot, you ask? Well, it's esquires. They're public enemy number one, hostile to the United States. And unfortunately, the commander-in-chief is surrounded by them, hiding as attorneys and lawyers and judges and justices and public officers. But at the end of the day, they didn't take proper oath of office, and so they're impersonating officers, and we should be able to charge them under the UCMJ. And I hope to show you that in just a second, sir. It won't take too long. If somebody knows Jocko, could get this video to him, however it's done, please message me at Rob Ryder on X. So, sir, let me get started. Give me just a second here, and I'll show you exactly what I'm talking about. And so, sir, this is as good a place as any to start. This is a document called the Roll of Attorneys that's kept by the Supreme Court of every state. Maybe they don't all call it the Roll of Attorneys, but in Michigan it's called the Roll of Attorneys. And if you get admitted to practice, you get your name put on the roll, and now you can practice. And as you can see, Dean Edward Rickberg was enrolled into the Roll of Attorneys. And that this document has been signed by the clerk and has the seal of the court, seal of the Michigan Supreme Court. Good enough, right? So this man here, in this name, is licensed to practice law in the state of Michigan. It's probably good enough to practice in a federal court. But when you go to the State Bar of Michigan website and look him up, it's not Dean Edward, it's Dean E. Rickberg. Dean E. Rickberg. Well, that's not the same name. And here is an example of him doing his business, right? He's saying that he is a trial attorney for the Office of the U.S. Trustee, U.S. Trustee, right? Dean E. Rickberg. But that is not the name that was licensed. It was Dean Edward Rickberg. So in this particular case, Dean, concealing his true identity, acting as an attorney, was involved in what's supposed to be a bankruptcy case against somebody with a middle initial name. So first of all, that can't be your legal name because your legal name cannot have any initials. Under the Real ID Act, no initials, no nicknames are authorized for the legal name. So Linda A. Allen could not get on an airplane with that name. Well, how can she lose her property in that name? To some honorable John T. Gregg, another Esquire using the middle initial. Right? With a clerk using the middle initial and a deputy clerk using an initial. And it wasn't even signed. Yet this lady, Linda A. Allen, lost her stuff to a bunch of Esquires impersonating as judicial officers of the state of Michigan. How does that shit get to happen, sir? Now, here's a case going on today in San Francisco where it was just reported that this judge in this case has issued an order stopping Trump from doing his agenda. But it was filed by a bunch of people using the middle initial. Again, that's not their full legal name. That is not the name on a roll of attorney. So they're not practicing under the name that was licensed to practice. They're concealing their identity. And so we're talking about, the attorney for the defense, the attorney for the prosecution, the guy sitting up there in the seat as the judge, the guy sitting in the appeals court, the guy sitting in the Supreme Court. All of them are not doing their business under the name they're licensed to do their business under. Now, this one's from a different case in Oregon where they weren't allowing President Trump to use the National Guard. Right? So it's these plaintiffs here. First of all, It's in the United States District Court for the District of Oregon. Well, there is no court named in the. It's United States District Court for the District of Oregon. Right? So, it's a jot and a tittle. It's wrong. So it's wrong. It's not the name of the court. Just like Donald Trump isn't Donald John Trump's name, and Pete Hegseth isn't Peter, whatever his middle name is, or Kristi Noem. Right? They're not using the full legal name of people in a legal matter. Well, then this must not be legal. That just seems to make perfectly good sense. But it's an order. Anyways, they did their deal. And if we go down to the bottoms, it is so ordered. And here is, well, guess what? Another Esquire using the middle initial, claiming to be a United States District Judge. So this is supposed to be the order of a court. But if you go and look at just one law, Title 28 of the United States Code for the Judiciary, 1691, seal and test of process, it says, all writs and process issuing from a court of the United States shall be under the seal of the court and signed by the clerk thereof. Do you see any seal from the clerk or any seal of the court or signature of the clerk? Of course not, because this isn't from a court of the United States. It's a court impersonating a court of the United States, run by people impersonating judicial officers of the United States. And as bad as that is, sir, it only gets worse. This is from the laws of the United States, Acts of the First Congress, right? This is when George Washington was president. This is the very first law, very first act of Congress signed into law by President Washington after the ratification of the Constitution on June 1st, 1789, in which it says that the oath or affirmation required by the 6th Article of the Constitution of the United States shall be administered in the form following, to wit, which means just like this, sir, where AB is the person's name, and A may be their name and B may be their social security number. I don't know exactly. I just know you got to put your name in. So I, full legal name, do solemnly swear or affirm that I will support the Constitution of the United States. Period. That's the end of the oath. Nothing else. Not a whole bunch of other stuff added. Just that. And if you look at subsection 3 of Article 6, it says that the senators and the representatives and judicial and executive officers of the states or the United States, blah, blah, blah. All these people need to take an oath. Well, this is the oath they're talking about them taking. Everybody in the 6th article that's mentioned, those offices, need to take this oath. Guess what? Nobody takes it, sir. I'll show you some evidence in just a second, but it goes on then that in Section 5, well, that the Secretary of the Senate and the House of Representatives, they have to take a particular oath also. What's the chances they didn't take their oath? There's one way to find out is to subpoena the records. Well, you can't do that when you're going to courts of esquires because this is their show, man. They ain't going to let that shit happen. So we need to take it to a court martial. So this is an act to regulate the time and manner of administering certain oaths, commonly called 1 Stat, S-T-A-T, 1 Stat 23, because it's in the Statutes at Large, Book 1 on page 23. Right there, 23, goes to page 24. Well, out of this came a derivative under Title 4 of the United States Code, having to do with the states, where it says that every member of the state legislature and every executive and judicial officer of the state shall, before he proceeds to execute duties of office, take an oath in the following form to wit. Reads a lot like what we just read, with the same thing. I, A, B, do solemnly swear I will support the Constitution of the United States. Well, they're not doing this, sir. Not only do they have to take the oath, I'm not going to read this whole thing, but they have to file the oath and be able to get a certified copy to prove that they took the oath. And until they can do that, they have no power to hold office. Right before he proceeds to execute the duties of his office. Now, let's think about this. How many people do you know that have gone through a foreclosure in a state court? Well, that fucktard sitting up there in the robe didn't have a proper oath of office. He's not a state officer. You can say that for any kind of court case. It's all the same. Now, none of these people have a proper oath of office. They're not who they claim to be. They're esquires, impersonating state officers. Okay, so if we took a quick look at Title II, which is the Congress, Title II United States Code, it says in subsection 21, oath of senators, blah, 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 take an oath, yada, yada. Then it has this codification, right, that RS 28, which is Revised Statute 28, which was what it was before it was United States Code, derived from an act of June 1st, 1709, 1 Stat 23. So they're talking about the oath of 1 Stat 23. Same with the President of the Senate, which would be the Vice President. He needed to take that oath as a senator and as the President of the Senate. And if we go down here, now we'll see we got the oath of speaker, members and delegates, and it talks about all the things they're supposed to do, and then that the clerk of the House of Representatives from the 80th in each succeeding Congress shall cause the oath of office to be printed and furnished, meaning 2 copies to each member or delegate who has taken an oath of office in accordance with the law, which shall be subscribed in person by the member or delegate, who shall thereupon deliver them to the clerk. We're talking about the clerk of the House of Representatives now, the one who had her own oath to take. One to be filed in the records of the House of Representatives, and the other to be recorded in the Journal of the House and in the Congressional Record. And we go down here and we see, well, codification. There it is, 1 Stat 23. See how they made sure that it was at the end of the line so that, break it up is not quite so easy to see, but it's 1 Stat 23. So what did they do? So as an example, this isn't as current as the current Congress, but it's close enough for government work. Congressional Record of the House for January 28, 2021, and we're filing down what they're doing. And then it's interesting that they adjourn for the day, and then they say they're going to take an oath. Well, they had already adjourned, so, this is being done on off-duty hours. And it was really supposed to be the first thing they did when they convened the Congress on the, I believe it would be the 3rd of January. So anyways, oath of office, members, residents, da-da-da. The oath of office required by the 6th Article of the Constitution, comma, well, that'd be the one that we just saw, and as provided by subsection 2 is some other thing, which is this one below, right? But they only put the one in. So this oath here is the same oath that a commissioned officer takes. It comes from 5 U.S.C. 3331. And you can see that it has a religious test, so help me God on it. So this cannot satisfy the 6th article by itself because it's got a religious test. The one we saw before didn't have any religious test. Right? But this one does, and this is the one they claim to take, and these are the names they claim to take it in. You can see we got people with middle initials and people you probably use. I don't believe Andy is anybody's full legal name, so it's probably Andrew, right? Eric A. Rick Crawford. Well, that's definitely a nickname. So all these people are using an alias to hide their true identity while avoiding taking the loyalty oath of the United States. Now, in King Henry VIII's time, that was a reason to have your head cut off. You can ask Sir Thomas More, except he's not here anymore. And there were a couple people in the Commons, I think they called it, right? Whatever the house is for the lower house in England, because they avoided taking the oath. So Henry VIII executed them. All these people here used a fictitious name, took a fictitious oath, and then they took another oath to get classified information using fictitious names. I think we have a problem, sir. So the whole civilian court system is mucked up with esquires that just, they're They're enemies of the United States, sir. They don't have any loyalty. Didn't take proper oath. What do? As it turns out, back in the day during the Civil War, President Lincoln signed General Order 141 that put the United States under martial law. So it says that during the existing insurrection and as necessary measure for suppressing the same, all rebels and insurgents and their aiders and abettors within the United States and all persons discouraging voluntary enlistment, resisting military draft or militia draft, or guilty of any disloyal practice, like not taking your oath, affording aid or comfort to the rebels against the authority of the United States shall be subject to martial law. This has never been rescinded, sir. If it had been, in the Lieber Code, it only gives 3 ways for it to be done. In Article 2 of the Lieber Code, none of those have been done. People point at other documents and proclamations that have been issued, but they did not remove the martial law from the United States. It may say United States of America, or it may list some states or something else, but this is over the United States, just like it says, so that's good enough for me. It's still in effect, which is fairly easy to prove. This is from the Army University Press, right? It's an official website of the United States government. And if you go down here to this particular section, where it talks about publisher's note on the use of Civil War terms, don't want to read the whole thing, obviously, but we'll see that similarly, citizens and states who remain loyal to the United States did not all feel a strong commitment towards dissolving the institution of slavery, nor did they believe Lincoln's views represented their own. Thus, while the historiography has traditionally referred to the Union in the American Civil War as the northern states loyal to the United States government, the fact is that the term Union always referred to all the states together, which clearly was not the situation at all. In light of this, the reader will discover that the word Union will be largely replaced by the more historically accurate federal government, or U.S. government. Union forces or Union Army will largely be replaced by the terms U.S. Army, federal, federals, or federal army. So when you say federal government, that's the term that was used in the Civil War during the time when the states were divided. The Civil War continues. It never ended. All that happened at the Appomattox Courthouse was that they had a armistice, which is a prolonged ceasefire. So the reality is that if we use the definition of a spy given in the DoD Law of War Manual, which is under Section 4.17.2, talks about spies, acting clandestinely or under false pretenses in a zone of operation of a belligerent, he or she obtains or endeavor to obtain information in the intention of communicating it to a hostile party. During a war, any person, military or civilian, whose actions meet all these elements is to be considered a spy under the law of war. And it gives a little bit better definition. Okay, what does acting clandestinely mean? Well, acting clandestinely or under false pretenses means deliberately concealing or misrepresenting one's identity and conduct. God, that's exactly what they're doing, sir. Esquires, pretending to be lawyers. Pretending to be lawyers, judges, justices, House of Representatives, senators, governors, state judges, state justices, state sheriffs, all of them. They're all have avoided, most of them not knowing so, but it doesn't change the fact that it is what it is. They avoided their oath they need to take. Just real quick, here's General Order 100, right? This was General Order 100, and the one we saw was 141, so this came before General Order 141, where it's instructions for the government of armies of the United States in the field. And it says under Article 2, martial law does not cease during the hostile occupation except by special proclamation ordered by the commander-in-chief or by special mention in a treaty of peace, concluding the war. So how do you know there's occupation? Well, this is the thing about the gold fringe flag, because that's a military flag. It's not used by civilians. Army Regulation AR 840-10, Chapter 2 will tell you that the design of that flag and then the places it can be displayed. And one of them is inside a military courtroom. We can go in the Supreme Court or any court, and there's a gold fringe flag with an eagle on the top, and the eagle is the finial for the president. So with that in mind, let me show you something else. These are the rules for the Supreme Court of the United States, which you can find on the Supreme Court website. And in those rules, on Rule 45, it says, all process of this court issues in the name of the President of the United States. Have you ever seen anything by them black robe priests that was done in the name of the President of the United States? Answer, no. Well, then that can't be the Supreme Court. But if the President of the United States issues something as the court, well, there you are. He is the Supreme Court. Well, so what are we to do? Well, here you are. Under the Uniform Code of Military Justice, if you go to Article 2, it says the people are subject to the chapter, and one is volunteers from time to time in their muster or acceptance into the armed forces, which means once you volunteer, you are always subject to the UCMJ. And because of that, you're not supposed to be subject to civilian court. If the civilians have a problem with you, they're supposed to take your ass to the post. If the post wants to release you to the civilians for you to stand trial, well, then there's paperwork to do. But, that isn't what happens. They just Shanghai you and take you into their court. And then they don't charge you. They just have you sit in a holding cell until you agree to sign some piece of paper for something so they can say that they charged you. It's a fucking evil system, sir. And just a couple other things really quick since we're here. If you look at Article 22, who may convene a general court martial? Well, the President of the United States can. Somebody should tell them. So can the Secretary of Defense, the commanding officer, unified or specified combat. I don't need to tell you, sir. You know better than me. You're an officer. I'm just saying, okay, it's easy enough to convene one. How do you do it? And if we go just a little bit further, you do it by Article 30, charges and specification. Charges and specifications may be preferred only by a person subject to this chapter. Well, that should be any volunteer, such as myself, such as you, such as whomever, all sorts of people. We're not being allowed to do it, but there it is. We should be able to do it. So it's the war pigs that are keeping us from doing it. You know what a war pig is. I know you do. Yeah, you're a Black Sabbath fan. Of course you do. Well, sir, I'm a child of the grave, or I'm trying not to be a child of the grave. Right, I'm that generation. One last stop, sir. If we look at the manual court martials for the United States, we go to jurisdiction, Rule 201, jurisdiction in general. It says a court martial always has jurisdiction to determine whether it has jurisdiction. So the thing is, you have to file the charges so the court martial can decide if it has jurisdiction. But you can't take it to JAG because those are all esquires. We've got to take this. This has to go to commissioned officers holding a command, or to the president, or to the Secretary of Defense, or go back up and see who's got general court martial convening authority and have them convene a court martial. Because, first thing they do is a preliminary investigation. If we could just get that far, go to the clerk's office and see the clerk of the House of Representatives and see if those people filed their oath. If they didn't file it, well then it's time for some gallows to go up. Of course, the commander-in-chief can always show clemency, but we have to put the charge in first to get this shit straightened out. And that's where we cut the Gordian knot, because we ain't never going to get this done in the civilian courts. And President Trump will never be able to unravel the Gordian knot in the time he has available. We can't unravel it, sir. We have to cut it. And here's a light bulb moment, right? This is Appendix 1 from the Manual of Court Martials, which says the Constitution of the United States, 1787. And you'll see here it says of the United States of America. Well, you compare that to the Constitution that Congress uses, which they say is the Constitution of the United States of America. Again, this was the Constitution of the United States. This was the Constitution of the United States of America. The Constitution of the United States of America says for the United States of America. The Constitution of the United States says of the United States of America. Not that that's a big deal by itself. Say that's a typo. Well, let's go a little further. Let's go to Article 2. The executive power shall be vested in a president of the United States, right? This is the one in the Manual of Court Martials. Let's go see what Congress says the power is. The executive power shall be vested in a president of the United States of America. They're saying it's in a completely different dude. Right? Because there is no president of the United States of America. Let's go look at the oath. In the Manual Court Martial version of the Constitution, it says, I do solemnly swear that I will faithfully execute the office of President of the United States. Oh, well, that's just supposed to have the executive power. Outstanding. But we go and look at what Congress says. It says that I will faithfully execute the office of the President of the United States. Okay, well, that's what it should say. But that isn't who they said had the executive power. The executive power shall be vested in a President of the United States of America. We ain't got one of those. We have a President of the United States. Whoever the President of the United States of America is foreign to us. And in fact, if you were to look at so in the civilian courts, Stephen K. Bannon, Stephen Keith Bannon is his proper name. So they're trying to John Doe, didn't use his proper name. And it's United States of America is the plaintiff. If you look at military courts, the plaintiff is United States. It's not United States of America. Two different jurisdictions where there should only be one. The one that needs to go is United States of America. The one that needs to come back is United States, which, because the martial law was declared back in 1863 and they went under whatever the plan was that came up after Reconstruction or for Reconstruction, right? All those people that were hired to do the work that needed to be done, run the courts, all the other stuff that had to do with running the government, they're all contractors. Right? They weren't officers of the United States, they were contractors. So that's what's happening is that these contractors have gotten together and they're pretending to be the government, right? It's administrative misconduct by hired help. So the clerks are running the show. They did the same thing in the church. The Catholic Church got the exact same problem. But, you know, that's probably who they learned it from. So I can't make it any clearer. So I don't know, I have really not much else. Other than there are no excuses that we veterans can't get this done. Right? If I had somebody to talk to who had some pull, I'd be talking to them. So I'm doing the best I can. I said, I'll talk to Jocko. Maybe he knows somebody. If you could just make a phone call, sir. Somebody. Right? Just find me on Rob Ryder on X, right? And send me a message. ROBBBRYDER. Right? I've been verified. I'm a real deal. And I'm going to leave it there. And God, I hope I hear from somebody. Thank you, sir. Have a great day.